and it is hoped that provision can be made for at least 6 criminal assize courts. This addition will certainly lift the disposal rate of criminal cases in the assizes, particularly in light of the disposal of the proposals I want to share with you. The provision of additional courts, however, will not be the complete answer. The approach to criminal justice is in need of fundamental restructuring. It is time to introduce a system, even if legislative underpinning is required, that is not only court-driven but purpose-driven, in the sense that on every occasion a case is called before court, a specific purpose is served, and not simply for the purpose of an adjournment. This is the cultural change that is required. Criminal justice is not served by adjournment. It is far better served by trial date certainty. Until we put in place those measures that will take us there, we are surrendering to the criminal elements in the society. I'm reminded of the words of Senior Counsel Martin Daly in an article written not too long ago, in which he said, by constantly conceding ground to the criminal and reckless elements in the society, we are putting the squeeze on those who wish to be law-abiding, and we are systematically destroying the cohesion that anchors a society when there is a common understanding of what is right and wrong. End of quote. When cases collapse because witnesses have been eliminated, when accused persons are acquitted because confessional statements have been deemed inadmissible, either because of the failure on the part of the police officers to adhere to acceptable standards or the refusal of a justice of the peace to testify, it is the society that suffers. Thus, one measure that requires immediate implementation is provision for videotaping the taking of statements from accused persons. This will immediately lift the credibility of those officers who go to great lengths to maintain integrity in what they do. It will also reduce time spent in long drawn-out voir dires to determine the admissibility of a statement. This, however, is but a small measure in the fight against crime. What we need is a complete set of rules that will move the criminal cases through the system effectively and efficiently, both in the magistrates' court and in the assizes. Some time ago, a system was put in place requiring attorneys to attend a causeless hearing, at which issues would be identified and various orders made in order to shorten the length of a trial. When all this was done, a trial date was fixed. Some attorneys complied, some did not. Slowly but surely, the system began to wane. There was no legislative underpinning, making it mandatory to attend the hearing. As a result, trial dates that were fixed well in advance had to be vacated. So it's time to make a change. One of the fundamental changes we need to implement in the criminal justice system is to replace the preliminary inquiry as we know it today with a more streamlined procedure to ensure that indictable offences are disposed of in a timely manner. I'm speaking about a system that goes beyond paper committals. How often has the question been posed, how come accused persons in the United States, for example, are brought to trial so quickly when it takes up years before someone can be tried in Trinidad and Tobago?